This is 100% self-defense, Tucker. Kyle, he's a good kid. He's a lifeguard. Kenosha was burning down. Actually, when he got done with work that day, he went to the high school with some friends to try to remove some graffiti. After that, they got a call from a local business person who owns 3 businesses in downtown Kenosha. 2 of those 3 businesses had been burnt to the ground, and this business owner simply wanted to desperately protect what was left of his life's work, so he asked for help. Kyle and his friends decided that nobody was doing anything to protect that community, and they decided that they would answer that call and help to protect that business.
Welcome to Law&Crime Report. My name is Bob Bianchi. I'll be your host. That is the attorney, John Pierce, in the Rittenhouse cases. I've been saying to you folks, it's going to get crazier and crazier. I just have that sense and the feeling about this particular case. A development has occurred. That was right after the preliminary hearing that occurred on September 1st that interview was done. This lawyer, Mr. Pierce, has now withdrawn from the case due to ethical concerns with regard to what the DA described as a slush fund with respect to money that he was receiving supposedly on behalf of the defendant in the case. There were all sorts of potential improprieties with regard to that. John Pierce has removed himself from the case. Let me get right to our 2 great guests right now. We have Gigi Gonzalez out of Miami, Florida, the daughter of a criminal defense lawyer. She's been doing it since the beginning to earn her allowance. I love that. And Mike Koribanics, certified criminal trial law and crime analyst. We have something in common, all of us. Each of our fathers are criminal defense lawyers, believe it or not. So it's all in our DNA. Welcome to the show, guys.
Thank you so much for having us.
All right, all right. So listen, the DA basically said this. He had significant, also the lawyer had significant financial difficulties. Mike, what do you think about this development? And I should note that he's withdrawing from the criminal case, but he's not withdrawing with regard to civil representation of Mr. Rittenhouse.
Bob, this is the kind of thing I don't like from square one on a few levels. Number one is you have to disclose to your client if a third party is paying parts of the legal fees so they know where things are coming from. But the obligation is constantly and always to the client. On the other hand, though, I am not so sure how the prosecution could jump into the case to have him removed on ethical principles, which you wonder how they found them, number one. And number two is, are they starting now a Sixth Amendment issue? This case and the way the representation is set up is just going to get more and more complicated as we move.
Yeah, Gigi, to Mike's point, that's really a good point. You have a right to your own attorney. It's enshrined in the Sixth Amendment. It's a really important constitutional right. There were other ways that you can go about this, like, for example, putting it in a trust, which I believe prosecutors asked. I don't think that he was required to be removed from the case, but he voluntarily withdrew. What are your thoughts about this case, which keeps getting crazier and crazier, and I anticipate will continue to get so as we go along?
Yeah, the situation is definitely weird. Yeah, I would love to read the motion because I, like Mike, find it troubling that the state is taking this position. And the fact that they're describing personal financial debts as a reason for this defense attorney to not defend Kyle Rittenhouse, that's problematic. What are you trying to say? That only rich lawyers with no debts are allowed to practice law here because otherwise they might take the defendant's money and use it for whatever they feel like it? You know, I find that very problematic, and I would love to know under what basis they believe that Pierce is going to use this slush fund, which I also have a problem with because this is money for the defense. This was money that was crowdsourced in order to provide Kyle Rittenhouse with the defense he needs, to pay for depots, to pay for investigators, to pay for experts. You know, and if at the end of it, whatever the lawyer earns for his time is his, and it should be spent however the lawyer feels like it. You know, if the Wisconsin state attorney felt like forcing Mr. Pierce to put the money in the trust, or if that's the way it should have been done, then I could see that being logical. But I also wonder why Pierce stepped down from this fight. What did the state have on him that he decided not to argue against them? This is definitely an interesting issue for sure.
Yeah, Mike, I mean, that's the point. I mean, the DA, we're seeing this more and more getting involved. We were, former prosecutors. We tried never to impinge upon that right of a person to have their attorney of choosing. More and more we're seeing the prosecutors are bringing this kind of game playing up. Now, that does not necessarily mean, to Gigi's point, that he had to withdraw. Are there any insights there? I mean, is this almost kind of like a little bit of look, this is, I got this money, maybe it's problematic, I'm concerned about investigating, this money is coming from third parties, outside sources. I mean, there could be a recipe for disaster there, but that's the responsibility of the ethics of the attorney, no?
I agree with you, Bob. Is it a situation I would like to be in as attorney? No. But is it something that the prosecution should bring up? I don't think so. I think it should start if the defendant has no problem with it. I don't understand what they are doing. It almost is on a subliminal level to me that they're sending out a message to any attorneys who are going to represent this defendant or any defendant is, we're looking at you attorneys too. And it's so uncomfortable and just not right. It's an ethical problem maybe, and that's the proper avenue and the proper, for lack of a better term, entity to look at this situation, not an adversary in a prosecutorial in a setting. It's just wrong.
Okay, well, you know, things were getting hot in this preliminary hearing. Ultimately, Rittenhouse did get bail, but let's take a look at the attorney's reaction to some of the things that were happening inside that courtroom.
My client in Exhibit 2 is running from Mr. Rosenbaum when a shot is fired by Mr. Zeminski, correct?
Correct.
Showing marked as Exhibit 3. That's a picture of Mr. Rosenbaum after he's been shot and he's wearing a mask, correct?
Correct.
It's a crime in Wisconsin to commit a crime while masked, correct?
In relevance.
When I hear somebody in the background, please refrain from saying something if there's somebody commenting in the background or making noises, please. Thank you.
Your Honor, I objected to relevance of this question.
Yeah, I that one, go ahead, I'll let you respond, Mr. Richards, but.
It goes to the events in question. The state is trying to put forth a one-sided, stilted view of what happened, protecting someone who doesn't deserve protection of the state. He's a masked robber.
Okay, this is preliminary hearing. I'm going to sustain the objection, and for purposes of preliminary hearing, that's outside the scope. It's not relevant for these purposes.
The individual on the far right of Exhibit 5 is Mr. Huber wearing the hoodie with 2 backpack straps, correct?
Correct.
Exhibit 6. This is a still photograph of the incident occurring at 61st and approximately 61st and Sheridan Road, correct?
Mr. Richards, are you testifying, or are you going to ask this witness to identify something? I understand you're trying to move the matter a bit, but shouldn't you
It's
ask
cross-examination.
this witness if he knows what that image is? All right.
Your Honor,
But you're not asking a question. You're testifying. Yes, you do, and I'm giving you that right.
Sir,
you don't have a right to make us to ask the. All right. Go ahead. Put the question in the proper form, Mr. Richards, and you allow it.
Okay. Sir, do you recognize Exhibit 6?
Yes, I do.
Okay, where that is in the area of 61st and Sheridan Road in the county of Kenosha?
Yes, sir.
And this is a still photograph from a video you reviewed?
Correct.
My client is on the ground, correct?
Yes, sir.
In the center of the picture, for lack of a better location?
Yeah.
And an individual runs up on my client, correct?
Correct.
You've watched the video. Does my client shoot that individual when he backs off?
Say when he backs off, I'm sorry.
My client does not shoot that individual or shoot at that individual, correct?
Correct.
The individual in the white pants running towards my client, that is the individual who jumps up and kicks my client in the head, correct?
It appears he attempts to. I don't think contact is made.
Okay, so that's a cross-examination of one of the detectives in the preliminary hearing. Mike, please educate our audience because it can get a little confusing sometimes What is this preliminary hearing? What are they trying to accomplish? And I'm curious as to what you thought about the judge limiting the cross-examination.
Well, number one is this is just a preliminary hearing. It says whether or not there's probable cause. Is there something more than a mere suspicion that a crime was committed? The rules of evidence are relaxed during these type of hearings. They are more, in my opinion, in my experience, more procedural than I don't know what the percentage is, but you very rarely hear of someone winning a probable cause hearing because the standard is so low. I have no problem with what the judge did with the objection, the objection of the prosecutor. I don't know if it was wise for the defense to start arguing about how you define cross-examination. If the judge sustains an objection, get back up and ask your question in another way. Get to where you need to go. Don't waste time arguing with the judge over something he really has no input in as far as evidentially, and he's just giving you an appealable issue, so move on.
So, Gigi, a tactical thing that we like to tell our audience, because so many lawyers watch it and crime aficionados, is that one of the benefits of the preliminary hearing for the defense is they get an opportunity to get discovery. Some people say that defense lawyers use this as a fishing expedition. They get to see how witnesses testify because you just never know. They get to see the measure of the witness, if you will. So there's always a value to that. But I respectfully will depart from Mike just a little bit here. You know, at least in the environment I grew up in the law, cross-examination is widespread. Defense lawyers are allowed to ask a lot of questions. They try not to limit it so that the record is preserved, that the defense got to do everything that they wanted to do. I personally didn't find it to be objectionable because it was leading in any way. That's what you're allowed to do on cross-examination. So Gigi, tell us the difference between direct and cross-examination.
Well, with cross-examination, you're asking leading questions. You are seeking to explore, the scope of the testimony that was expressed during direct examination, which usually that's the state attorney asking the witness that they brought forward or the lawyer that brings their witness forward, and they're asking exploratory questions where the witness is answering questions as to what they perceive to happen at the time of the event and what their scope is. And like Mike mentioned earlier, with preliminary hearings, the rules are a little bit more relaxed. So I was surprised to see that the judge did rein in and narrow the cross-examination scope here. But just like Mike said, it's important to just keep it moving, take your hits as they come, and keep it moving, because it really does distract from the narrative and what's going on here. And I think that the defense attorney was really doing a good job in cross-examination by trying to establish a good self-defense position. Like he was on the ground and he was being approached by multiple people and he was being kicked out while he was down. I think those were all positive points to bring out during this cross-examination. And like you said, Bob, preliminary hearings are great because they are exploratory. We do get an insight into where the state is coming from, where they're planning to go with their case, what the witnesses may say. So, while it is a fishing expedition, it's an important expedition for the defense to embark on.
Yeah, Mike, I agree with Gigi. I mean, I think it was an effective cross-examination in terms of its substance. What are your thoughts about where the defense is going with this case and bringing out those particular facts to say this was not a purposeful or planned thing? This was something where he was defending himself.
Well, Bob, I don't think I agree with what you both say on cross-examination. I just do not believe this was the proper forum for the defense, because the defense did for the prosecution what we usually look for the prosecution to do to us. They're laying out the weaknesses of their case at a hearing, which I don't think it's worth doing it at, since the bar is so low for the prosecution to win. And I think they've helped shirt up the prosecution's case in this by that cross-examination and showing where the defense is going, which they're not obligated to do.
Right. And Gigi, another important point, in addition to getting information, is that the defense attorney is locking the state's witnesses into certain answers so that when it goes to trial, anything that they said under oath in the preliminary hearing can be used on cross-examination if they say something different, no?
Exactly. They can totally be impeached on this. Everything that they say is under oath, and it's being transcribed by a court reporter, and it'll be easily referenced later on. If, for example, the witness says something different on deposition than the witness testified to here at the preliminary hearing, excuse me, that'll be an opportunity for the defense attorney to impeach whatever the to impeach the witness on whatever they say if they happen to contradict what they said at the preliminary hearing with what they said at the depot or what they say at the trial later on.
Awesome, awesome. Okay, guys, listen, we're going to have to take a turn right now, take a quick break, but don't go anywhere. We got Breonna Taylor, Ghislaine Maxwell from the Epstein fame, Pornhub, the case about them, Jim Crow laws, as well as the Tiger King is back in the news. We'll be back right after the break.
Our team walked them through every homicide offense and also presented all of the information that was available to the grand jury. And then the grand jury was ultimately the one that made the decision about indicting Detective Hankinson for wanton endangerment. I think that in terms of what happened the wee hours of March 13th, in terms of that particular or specific date and what happened that night in the apartment, I think it is unlikely that there will be any additional prosecutions that come from that event itself.
That was the Kentucky Attorney General, Daniel Cameron. Mike, I got to go to you on this one first. We were talking about this when the show first started. Now, they wanted a special prosecutor because it was a conflict of interest that got pushed to the Attorney General's office. This is starting to become a tortured history. The family for Breonna Taylor does not want the Attorney General to handle this case anymore and asked for another special prosecutor. But as you recall, when we first listened to that statement, Mike, we were saying as prosecutors who've presented thousands of cases before the grand jury, please tell me that he presented all the evidence and all the possible charges that could be filed against all of the police officers. And what we're learning is that no, it was really limited to the former police officer, Brett Hankinson, who was indicted for shooting at an adjacent apartment and endangering the lives of those folks in that apartment. And to me, the Attorney General is losing a tremendous amount of credibility. Just so our audience understands, when Ben Crump, who's the attorney for the family, asked for another prosecutor to be assigned based upon that information that was coming out from Attorney General Cameron that he may not have presented charges against the other officers as it relates to the killing of Breonna Taylor. Basically goes before a nine-member council, and that nine-member council is comprised of people from the AG's office, the Commonwealth attorneys, 3 county attorneys, and 2 citizen members that are on that board. And they said, no, there will not be a special prosecutor. Mike, I would agree with that decision if it weren't for the fact that we are learning that evidence pertaining to the killing of Breonna Taylor was not even brought forward to the jurors, and charges against the officers were not presented to be charged. And my last comment, Mike, is we all know how grand jury proceedings roll. And so our audience understands there is no defense lawyer in there. There is no real opportunity to present any evidence. It's the prosecutor's playground, as they call it. So you have to be pristine in making sure that you have a record that shows you were being fair and impartial. What do you think, Mike?
I got to tell you, Bob, I am shocked. I am shocked at the response from the acting prosecutors in this case. I cannot believe all the evidence was presented. When I first heard it, Bob, as you listen, we're all attorneys here. We deal with these kind of cases every day. Granted, this is a much different, game-changing in our history type of case, but the principles still are the same. And the principles should be even more adhered to make sure that victims get the proper representation in the process. And what we're hearing and what grand jurors are saying is almost unbelievable, that all the evidence wasn't given to the grand jury so they can do their constitutional function and decide how the person should be charged. You can't have it limited and editorialize to get the charges you want. And I think that's what what Breonna Taylor's family is concerned about. And I think they're right. And I think Mr. Crump is right as well.
You know, Gigi, Mr. Crump basically said that it was a new level of cowardice by the Louisville Police Department, the Attorney General, and now this council. He called it staggering. You know, there's a reason for keeping grand jury proceedings protected from the public, but we have seen that many instances, to Mike's point, it has been a place where prosecutors have abused that privilege. And so for purposes of transparency, these proceedings are getting out more and more so that the public can see. We had a famous case in Jersey not too many years ago where the assistant prosecutor was saying, you need to see the grand jury minutes so I can prove to you the evidence was presented, and they were never allowed to be released. So unfortunately, one side never got an opportunity to make its case about the improprieties in the grand jury. So what are your general thoughts about the whole way this case is going down, and in particular, Mr. Crump's idea that this was a staggering miscarriage of justice? I mean, it just doesn't look good.
Well, I got to be honest with you. I think Ben Crump put it really, really nicely. And I think he minced words a little bit, because what's happening in Kentucky is, quite frankly, pretty shocking. The fact that the only way that, Breonna Taylor's family can seek justice is by putting the heat on Kentucky. Remember, Breonna Taylor was murdered in March. And the only reason why we even came to know about it was months later, when the Ahmaud Arbery and George Floyd killings sparked this conversation. Hey, don't forget about Breonna Taylor. She was murdered by the police 2 months ago. And then it started getting hot, and then we started seeing movement. And quite frankly, this entire outcome is disappointing, but not surprising. When Daniel Cameron said that it was unlikely to see any new changes stemming from this, he was absolutely right, because we've seen time and time again that the laws are designed to protect law enforcement in this case. And in the eyes of Kentucky, they already settled this for millions of dollars, and they already enacted police reform in the name of Breonna Taylor. So they've done enough for the Breonna Taylor's family that they don't need to go further by appointing new prosecutors or doing a new grand jury or anything like that. I think that Kentucky is pleased with itself, and so long as there's no heat on Kentucky, we're not going to see anything new here.
Yeah, real quick, guys. So there's two important points. To be fair, and we don't know what all the facts are. Prosecutors are not supposed to present cases to a grand jury that they don't believe they have probable cause for, or that they can prove beyond a reasonable doubt. The question is it a murder, or was she killed, is the question here. But I'll tell you, if you want criminal justice reform, Mike Koribanics, in the state of New Jersey, if there's a police-related fatality in the use of force, it must be presented to a grand jury. Now, some police officers get upset with that, and I understand why when we did everything well. But you know what? If the cops didn't do anything wrong, it would have been a greater service to the police officers to present the evidence and then have the cover of the grand jury to say, the grand jurors listened to all the evidence, we gave them all the possible charges, and they did not indict. A far better position to be in than this.
It is, Bob, but in fairness, as you say, and you, Bob, being a head prosecutor, know as well, too, is sometimes as prosecutors, you have to be the gatekeeper. I'm speaking generally now, not specifically in this case, so that you don't allow emotions, political views, things of that nature, to take over the case and have a grand jury run away with it. That's also a problem on the flip side.
Yeah.
So these are not very easy. These are complicated questions without simple answers. So, but what you need to ensure at the very least is that whoever the gatekeeper is, that they are watching that gate strictly with their ethical obligations and not influenced by anything outside those ethical obligations.
Yeah, really amazing. Guys, got to switch gears a little bit. Lucille Maxwell, out of the Epstein case, she was charged as a co-conspirator on some massively bad federal charges that carry a significant federal prison sentence. Mike and myself have actually worked on cases like this. We could tell you that firsthand. Well, she was denied bail, and now she's making a new bail application. We're being told it's going to be filed probably under seal today, with a defense attorney saying that there's new information that would change the judge's mind that she was and has an extraordinary capacity to avoid detection. The defense lawyer argues, Mike and Gigi, that the defendant is woken up every 15 minutes by flashlight to see if she's still alive, that it is de facto solitary confinement, and that she is subjected to extensively and invasive searches, obviously trying to avoid what happened in the Epstein case. Mike, what are your thoughts about this?
I don't think it's a good move, Bob, especially in this case. You've got to, as a defense attorney, advise, although we can never guarantee, you have to advise your client that you're here to win the war, not just little battles. This judge is probably going to handle the case throughout. And every time you submit a certification in a hearing that you're probably not going to win, that could come back and hurt you at trial. So you need to explain that to your client and explain to them that maybe these 15-minute wake-ups and things of that nature are not unusual because you are, in fact, in jail, that they're not unusual and part of policies and procedures. And I really don't think that is going to move the day in having her released. We see, Bob, day to day during this COVID pandemic, clients were filing for compassionate release, things of that nature. And why people think it may be easy to get out, it is not. So you've really got to do your risk-reward evaluation every time you file a motion.
Yeah, Gigi, though, representing a client, to Mike's point, especially during COVID-19, when they are in jail, is exceedingly difficult. You don't have access to them. You can't bring a lot of your files in or computer records. This is an extraordinarily expansive investigation. And then you have a client who's being woken up every 15 minutes so that when you even do get to see them, it's very difficult, Gigi. What's your experience in representing somebody, especially in a case of this magnitude, when they're in an incarceration setting?
Oh, well, my federal case that just got paused, it's been incredibly difficult to be able to go visit my client. I haven't been able to. It was already hard enough to go over discovery before COVID. You have to lug everything in. You have to have all your files. You have to pre-approve your computer. You're only in there for a set amount of time. It's really difficult to prepare for trial when your client is in prison, whether federally or in state prison. Meanwhile, you have COVID, which makes it even more difficult. You have to apply for online visitations, and then you have to make sure the internet connection is set up, and then you have to figure out a way to share discovery virtually. It is very difficult. So I could see the benefit of the defense, and especially Ms. Maxwell, wanting to get out. And the bail package she put forth better be good. I see that she has friends and family putting forward assets and collateral. I see that she has opened up her assets and her financial statements for the past 5 years in hopes of convincing the judge that she is not a risk of flight, and that the money that she puts forward and the collateral and the assets that her family and friends put forward will be enough to ensure her presence in trial.
Yeah, Mike, listen, to be fair on all sides, it's a horrible case, but she is presumed innocent under the law. Having her come to trial is the main issue. The judge was worried about her ability to avoid detection, but as well as I do that the probation services in the federal courts are amazing at tracking them with ankle bracelets with regard to reporting requirements. They can have some pretty in-home detention. They can have some pretty draconian control over her. So I'm just asking, is maybe the judge more inclined not to do this because of the publicity of the case and the way it looks, as opposed to, look, we've had cases where people charged with similar offenses have gotten out under those conditions and were not a flight risk?
I think it's an excellent question, Bob, and I think the judge has to, in this instance, number one, really look to other non-millionaire defendants. I understand she's a millionaire. So it shouldn't really come down so much, because we've heard so much about criminal justice reform as to how much somebody could put up financially, things of that nature. It really goes to how are other similarly situated defendants treated on pretrial release. But to your point, Bob, it's I don't know of anybody who's evaded the federal government, especially with the very meticulous job pretrial services does to make sure they could keep tabs on where that person is while they're out on bail.
Right, passports taken and everything. Guys, there couldn't be a better segue than Pornhub is under the crossfire. I'm going to give you a statistic. 42 billion visits last year. We're going to talk about it on the other end of the break.
Chances are you've been a witness to a crime. It's the epidemic of human trafficking, and it happens all over Missouri. I'm Josh Hawley. As Attorney General, I'm going to do everything in my power to stop it. We're going to train Missourians in all kinds of professions to recognize human trafficking so they can report it, and we can prosecute it.
All right, the focus of this is based on some stuff that came out about Pornhub, but it relates to a lot of adult, quote unquote, entertainment sites. And I told you before, last year there were 42 billion visits at the Pornhub location, an average of 115 million per day. And there were 6.83 million videos that were uploaded in 2019. And essentially what is happening here is that while the company is saying it has a zero tolerance policy with regard to trafficking and child pornography, an independent group called Internet Watch Foundation found out that there were, in their estimation, 118 instances of child pornography being put on the website between 2017 and 2019. Pornhub counters that with saying that they've already worked to employ extensive measures to protect the platform from such content, and that there are human monitors reviewing every single upload, flagging systems to remove illegal videos, parental controls, as well as automatic artificial intelligence detection technologies, and that they are not in any way engaged in trying to do this. However, this Attorney General wants to pass laws that eliminate immunity for people on the internet, where there's a lot of immunity protections there. And in 2018, President Trump signed into law something that very much is similar to that, that they are going to be responsible if those things are on the internet. Gigi, let me go to you first. I mean, this is a huge multi-billion-dollar industry. There are 118 incidents, at least from 2017 and 2009, that this independent watch group looked at. Is this law by the Attorney General a good law, or is it overkill based upon already the regulations that impose significant civil liability should child pornography or persons that were involved in human trafficking wind up in pornographic videos?
I think this is good law because it's going to give, teeth, and it's going to give porn sites like real fear of what may happen if their users use their platform to upload child pornography. I understand that the statistic is 118 child pornography videos uploaded between 2017 and 2019. I wouldn't be surprised if that number is grossly underestimated. The amount of child sex victims that we know of is staggering. It's an incredible amount. So, by adding this legislation, what you're going to do is you're going to promote Pornhub and other porn sites to, ensure that their users aren't uploading content. Because what the problem is that it gets uploaded and maybe it gets flagged and it gets removed only to be found on the internet a couple of days later because it's re-uploaded and recirculated throughout the community. So this legislation, I think, is definitely going to add teeth to the situation.
Mike, when you were a prosecutor, you were in the sex crimes unit. We also have a situation here where the age verification is where I see a biggest problem here. I'm from reading articles and looking at what they're saying. People can get fake licenses or fake identification, go in, and the guy just wants to see basically a library card. Oh, you say you're 18, you're all good with us. And then they want to rely on, hey, we did age verification. They presented this proof and this evidence. Is there anything more that you think that they can be doing? Because according to them, there's a DOJ guidelines with respect to what they should be doing. And Pornhub claims they have been following and exceeding that. What are your thoughts about all this?
Well, it's just so very complicated, Bob. I mean, who knew the internet was ever going to take off as quickly and progress so quickly? And it just makes the enforcement of criminal law much more difficult because of all the different angles that content comes to the internet. You and I both know, Bob, that the age verification is huge in these matters because users better be careful because there's strict liability if people on Pornhub come across something that is child porn and they don't believe it to be so, but it's later found out. Each state has some states have very strict liability, was like, it doesn't make a difference what you thought, it's the actual age. That's very, very dangerous as well. So this legislation is going to, I imagine, take a ton of time to get through because of all the different competing interests.
Gigi, I mean, to the point that Mike just brings up, that somebody innocently can be watching this thinking that they're looking at something that is not child pornography, which is just really, such a dangerous thing here. Is there a way to shut this business down? I'm just curious. Or are there First Amendment issues that are at play that keep them alive?
Yeah, there are First Amendment issues at play. As we know, adult pornography can be circulated. It can be created, so long as everyone's consenting and so forth. What I think is interesting here is that you have the First Amendment rights of people to engage in and partake in pornography, but then you have also the rights of child sex victims to not have the evidence of their abuse circulated for the pleasures of adults. What I think is interesting too is how are they going to regulate this? What's the difference between one person who clicks on a young teen video and then the person who has thousands and thousands of hours of history searching young fit teen, or whatever these confusing terms and search phrases are? How do you differentiate one person who might have seemingly come across innocent seeming video only to find it was actually the victim of a child sex ring versus the other person who's just engaging recklessly in Pornhub, videos and whatever is being brought to them based on the algorithm of their preferences. It's really difficult to decide what is the appropriate measure here. I think we could talk about it for a bunch of segments and still not come up with the best answer.
Yeah, Gigi, I think what I'm hearing you say is that somebody could actually be looking for child pornography, 14-year-old, 11-year-old, 10, which there are sites out there on the dark web, I'm told, where you can do that, as opposed to a person who innocently and accidentally believes they're looking at an adult, but turns out not to be. The punishment is still the same. Okay, listen, we got to switch gears a little bit. Rhonda Johnson, I want to talk to you about her. She's out of Louisiana. She's serving a 20-year sentence for a 2009 stabbing of a man that she said she was the subject of police prosecutorial misconduct, ineffective assistance to counsel, that it was really a self-defense case. She went to trial, and a non-unanimous jury, that is a jury less than 12, found her guilty. But had she been in all but 48 other states, that would have resulted in a mistrial and a hung jury. The Supreme Court in April of 2020 ruled in a 6-3 decision that there is no longer a non-unanimous verdicts. That is a constitutional guarantee that 12 jurors have to find you guilty. So the issue with regard to Rhonda Johnson and thousands of others is, should those who have had convictions on less than 12 jurors be looked at retrospectively, go back retroactively, and actually reverse those convictions, given the Supreme Court's ruling of the importance of having a unanimous jury. And I will also note, guys, I just want to make sure our audience understands, there is a history of this having occurred in the 1800s, and then it was updated, I believe, in 1974 and 2018, where it's been outlawed in 2018. But prior to that, there was actually a quote that I saw in Louisiana in 1898, where the conversation was basically they want to pass this in order to have whites be supreme over black individuals, hence the Jim Crow laws. Mike, what do you think about applying this retroactively, which would be lots of people getting outright dismissals because prosecutors won't be able to put cases back together again?
Oh, Bob, it's a very, very high bar in the United States that the Supreme Court set in a case, I believe, back in like 1990, 1989 in Lane versus Teague about retroactive application. While it sounds great as we discuss it here, there are serious practical putting forth these decisions on people who were already sentenced. And the retroactivity is a huge question, because they're coming from a Supreme Court going back to state courts, and there's going to be a lot of conflict, and it's very rarely done to cases that are already been decided and are final, where they will reverse them. So I don't know about the retroactive application. It's almost unbelievable in this day and age that we don't have unanimous juries, because I think you could ask any grade school student who studied civics about a unanimous jury in a criminal case. And some of these places like Louisiana, it is unbelievable, but the Supreme Court's addressed it. I think it was a good decision. It's going to be interesting to see how they contextually put it with the retroactive aspect of it.
Yeah, Gigi, I agree with Mike's analysis and what typically is done with regard to retroactivity. But I point to this: if I were a justice, and I always try to put myself in the place of the adversary or the judges that are listening to the case, it's one thing to change laws and not make them retroactive because they were valid at the time. But when we look at a law that basically says we are doing this because of racial reasons, and the basis for it was to do something that is so antithetical to the Constitution, then I don't know, you kind of own that in my mind. And if the price for that is that people get released after serving 20 and 30-year sentences, then so be it. Next time, don't do something that is so blatantly unconstitutional, because you did this, not the defendant. You did this, the state, and the state should make good on that.
I completely agree with you. I mean, let's consider, the racial aspect of this law, right? It was enacted in order to preserve white supremacy. So now let's also consider the fact that out of the 1,500 ununanimous jury verdicts reached in Louisiana, 80% of them were Black. So now we know that this legislation was inherently racist and inherently discriminatory on its face. And when we're talking about practicality, what is the practicality of retrying these cases? The argument that was set forward was it's not going to be that big of a deal. It's 1,500 possible cases. That means 2 to 3 new cases on top of the prosecutor's load, which when you consider how many cases a prosecutor has, 2 to 3 isn't that many. And when we think about what the Supreme Court was thinking, I actually think it was Elena Kagan that mentioned, whether it was the right thing to do when, there's potentially guilty people that are going to be released. Well, that's fine. If it means one innocent person is released because of this inherently racist law, then that's good enough. And like you said, Bob, it'll send a message to any legislators who think they can get away with promoting these types of racist laws to think again.
Yeah, it's unbelievable because the law was based on that. The law may have been effective to 1, 2, 3, 10, 100. We don't know. And prosecutors still have the ability, after the cases are reversed, to try them or plead them out to time served, which is definitely a viable option as well. Great commentary as always, guys. Listen, we can't get rid of the Tiger King. If you can believe this, I didn't watch the series. My wife watched it from beginning to end. I know I could be the only guy on the face of the earth that did not watch it, but there is now a Tiger King law being proposed. We're going to be talking about it on the other end of the break. Stay with us.
It's not every day that a zookeeper went to prison for murder for hire.
There are more captive tigers in the U.S. than there are in the wild throughout the world.
Animal people are nuts, man. They're all crazy. I'm sure y'all got a story to tell.
Well, that Netflix special has caused the United States House of Representatives to pass a Tiger King law, 272 to 114 votes, called the Big Cat Public Safety Act, which bans breeding and ownership of big cats without licenses from the U.S. Department of Agriculture. Many Republicans complaining that this is something that will hurt small family-run operations, as well as the small stuffing animal business. Mike Koribanics, what do we do here? Are we in favor of this law here or not?
Well, I don't know. All I know is you're Bobby the Beagle King, Bianchi, because I know your passion for that legal beagle you have. But I think this is something that needs to be looked at, because I'm sure there's public safeties, but I am very unfamiliar with lions and tigers and bears. Oh, my.
Yeah, well, we're very well played, Michael Koribanics. Very well played. Gigi, I got to say, I am an animal guy, right? And I do have Holly, the legal beagle. And some of these abuses that we've seen, unfortunately, led to this. So what are your thoughts on, you could still get a license, but they're just limiting it dramatically. So maybe more controls, better for the cats, better for the owners. Because the Tiger King guy, Joe Exotic, well, he's serving 22 years for wildlife crimes and a murder for hire plot. So what do you think?
You know, what I think is, first of all, I found it interesting that when I was watching the Tiger King and I was keeping up with everyone's Twitter, everyone was so amazed at how easy it is to procure a tiger. Right? I think there was a viral tweet that went around that said all I needed for my forever pal was $5,000 and I could have had a tiger. So I think this bill is seeking to eliminate that prospect of your neighbor being able to get a tiger because they've got $5,000 in the bank. This is what that bill is tailored to. And I will say,
Okay.
Bob, that if
I
you
agree
are the
with you,
legal
G.
beagle, then Mike Koribanics is the fat cat.
All right, we're going to end it on that, folks. That's a great line, guys. I will be back on Thursday. Stay tuned for our regularly scheduled programming here at the Law and Crime Network.